Hello everyone, and welcome to the NGT Briefing, the series that breaks down the key debates around new genomic techniques in the EU, one issue at a time. Today we are diving into one of the hottest topics in the EU NGT debate, intellectual property. What is breeders' exemption? What is even patentable? And how might new rules affect breeders, farmers, and innovation across the agri-food chain? I am joined by three brilliant voices from across the agri-food chain to help us answer these questions. Let's get into it.
My name is Hélène Guillot, and I'm a lawyer. I used to work for the International Seed Federation, ISF, and then I recently moved to the SCLP, the Agricultural Crops Licensing Platform.
I joined Tropic a couple of years ago. During my training, I became qualified as a UK and European patent attorney, and just specialising in the biotech world, and now more specifically within the agritech sector.
I'm Peter Button. I started out for a plant breeding company in the UK where I produced stock seed of new varieties, and then an opportunity arose at UPOV, the position of technical director, before becoming Vice Secretary General at UPOV.
Since you're an expert in this field, could you briefly explain the main forms of IP protection available to breeders using NGTs?
So the first one and the most well-known one is the plant variety protection from the UPOV conventions. And the main feature of this tool is the breeder's exemption, meaning that a breeder can take any variety commercialized on the market and use it. The second tool that is getting attention now is a patent. The main convention is called the European Patent Convention, which is gathering around 40 countries.
What you can do within the EU, you can get a patent for your NGT method. So that could be using CRISPR to knock out gene X for trait Y, and you can protect plants that are generated by that method. So you can protect these NGT plants, but nothing conventional that could also have that similar trait. The purpose of the patent system is essentially to be a tool for innovation, and that's frankly because innovation takes time and costs money. And that's especially important within the startup SME world. So what they are doing is they're spending money in the hope that they can recoup that later. And what patents do is they allow them to protect that innovation. Patents really do support startups and SMEs to get off the ground, to get investment, to develop their products. If you take those patents away, you will greatly handicap this sort of nascent area of the sector. And I think what will happen is you'll have few startups, SMEs, actually developing solutions for the EU market being based within the EU, because it would be such a challenging environment for them to face if they couldn't protect their innovation. So I think, the concerns for me is you could undermine the purpose of this regulatory docket, which is to stimulate innovation in NGTs, hopefully led by startups and SMEs. And you could have a bit of a desert there.
Patents are actually a way to share innovation, because when an inventor discloses his invention to the European Patent Office, he is actually disclosing everything that has to be known about his invention, and publicly, and this is really a great way to share innovation.
Intellectual property rights were created as a mechanism to deliver benefits to society. We need innovators, we need people to invent things, but in order for them to be able to spend the time and money to do that, they need to be able to receive payment for what they're doing. And what the intellectual property right effectively does is enable them to be paid for their work. And I mentioned that many people think intellectual property rights are there to benefit companies, and often they associate it with large companies. But again, this is a real misunderstanding that in fact that legal protection means that all potential users have the same rights, whether they be an individual, an SME, or a large company.
I think that what often comes up in a debate is, what about farmers and breeders? Are there mechanisms that would ensure farmers and breeders to access the seeds that are protected by the IP?
I think the plant sector is really quite lucky within the IP world of having quite a lot of protection almost sewn into the law for farmers and for breeders to innovate from protected varieties. So this can be divided up into these two types of IP, the plant breeders' rights and patents, and I'll address them separately. So for plant breeders' rights, there's something within the EU called farm save seeds, and this allows farmers to save some of the seed that they might have harvested from a legitimately bought protected crop to use on their own holding. For breeders, there's the so-called breeders exemption, and this allows breeders to use protected varieties within their breeding schemes to allow them to innovate from these protected varieties that are protected under the plant breeders' rights scheme. And so that gives them room to innovate despite IP being there. And actually, I think this is a bit of a misunderstanding. In terms of the breeders' exemption, the same is also applied in patent law. A lot of national patent laws in specific countries within the EU also has this breeders' exemption. So Germany, France, the Netherlands, for example. So there is quite a lot of protection for breeders, for farmers, that's already hardwired into the plant breeders' rights system and the patent system.
The EU Council has proposed a voluntary online disclosure system for NGT patents. What's your view on that approach?
We know that these are the main problems when talking about patents. There has been a database called Pinto, which is in place for 10 years now, and the seed sector has put in place this voluntary database for companies to display which varieties contain a patented trait. Also, there is an initiative from the private sector, which is the licensing platform that I'm representing, the SCLP for agricultural crops. The SCLP is gathering around 95% of the patented traits that I mentioned before. 95% of the patented traits in agricultural crops can be accessed through this licensing platform. The platform has two main features. The first one is to propose the limited breeding exemption that I mentioned at the beginning. I said that in the legislation in the EU, the limited breeders exemption is only available in a few countries like France, Netherlands, Germany, Switzerland. But if you are a member of the platform, you get this limited breeding exemption for all the territory of the European Patent Office. And the second thing that the licensing platform proposes is, in case the variety that is commercialized, so by a breeder or a member of the platform, still contains a patented trait, then you need to access to get a license from the patent owner. Then through the licensing platform, you can get guaranteed license, which is something very interesting, and especially for small and medium companies, which are really the focus of policymakers in the EU.
Now, if we think of the EU and the IP rules that they are trying to impose, would you say that there are specific risks for Europe's global position in the agricultural innovation?
Yes, definitely. The first risk that we can see is that companies who have the possibility will just move out their scientific research out of Europe. They will go in countries where they can do all the research that they wish to do. If the breeders don't get the new tools that they can access, and all the other parts of the world are going quite in a direction where the toolbox of breeders is increasing and in Europe it's decreasing, well, we will just stay behind and farmers will not have all the right seeds to address the needs, because there will be new diseases coming, there will be new pests, new virus to fight, and we know that the climate is also changing and we need also seeds with able to address droughts, etc.
European Union is already behind, I would say, in this game. European farmers are already behind in terms of access to technologies that will enable them to be competitive globally, but also will enable them to be more environmentally friendly in their farming.
What would be your final message to, let's say, our audience and also to EU regulatory bodies when it comes to IP in the context of, new genomic techniques?
There aren't many NGT SMEs and startups in the EU, and I'm not entirely sure their voice and how important patents are for their future has necessarily been well heard and well understood by the by the various decision makers. We all want, I think the whole EU wants this NGT regulation to truly deliver on the potential of this technology for the sector, for the sustainability of crops, for increased yields. So yeah, let's talk, let's be open-minded, let's try and stick with the facts, and yeah, let's make this happen in the best way it can.
That is it for the first episode of the NGT Briefing. Huge thanks to Richard, Elena and Peter for helping us unpack this complex issue. Stay tuned for our next episode. We'll be tackling another big issue in the NGT debate, traceability and labeling. See you then.